Your landlord ignored that broken stair for 3 months and then you slipped right through it like a cartoon character falling into a manhole. Funny in a movie, not so funny when your ankle looks like a question mark. Here's the deal nobody tells you when you sign that lease. Landlords have a legal duty to keep common areas and your unit reasonably safe, and reasonably does not mean whenever they feel like it. Think about it like a restaurant kitchen. If the health inspector finds mold growing on the ceiling, nobody says, "Oh, that is just character," they shut it down, and your apartment deserves the same standard. So can you actually sue? Usually yes, if you can show the landlord knew or should have known about the danger and just sat on it like a cat on a warm laptop. This is called premises liability, which sounds like a fancy spell from a wizard school but really just means the property owner is responsible for keeping the place from turning into an obstacle course. Now here's where people get confused. Just because you got hurt does not automatically mean you win, because you also need to prove the landlord had a reasonable chance to fix it and chose not to. Picture a leaky ceiling you reported 4 times in writing. That paper trail is basically your superhero cape because documentation is what turns your story from he said, she said into a real case. A lot of folks think renter's insurance covers everything, but renter's insurance protects your stuff, not the landlord's negligence. Those are 2 totally different superheroes with 2 totally different capes. Common cases include broken stairs, faulty wiring, busted locks that let in intruders, and ice on walkways that never get salted. Basically anything where safety took a vacation and nobody called it back. Here is a twist most people do not expect. Sometimes the landlord tries to blame you, saying you should have seen the hazard, which is why photos, witnesses, and timestamps matter more than your Instagram aesthetic ever will. There was a case where a tenant in a building with 1 working elevator out of 3 had to climb 12 flights for 2 weeks straight before finally falling on a cracked step, and the court said the landlord knew and did nothing, so the tenant won. Doubt creeps in here because lawsuits sound expensive and scary, like fighting a dragon with a butter knife, but most injury lawyers work on contingency, meaning you pay nothing unless you actually win. That changes the whole game, because suddenly the size of your wallet does not decide whether you get justice, the facts of your case do. The lesson nobody puts on a motivational poster is simple. Document everything, report problems in writing, and do not wait around hoping the landlord grows a conscience overnight. If you want to learn more about how this actually works for your situation, check out our links in the description. Would you like that?